election. Minutes later, Judge Juan Merchan sentencing Donald Trump to an unconditional discharge, meaning the guilty verdict stands, but Trump receives no jail time, fine, or probation. The judge telling Trump he was not treated any differently than any other defendant. President-elect Donald Trump will now become the first president in U.S. history to take office as a convicted felon. He was found guilty last year of 34 counts of falsifying business records to hide hush money payments to a porn star. Trump has indicated he plans to appeal the verdict.
This was a disgrace.
Political analysts like Shannon Bo O'Brien of the University of Texas say this case was personal to Trump.
He doesn't like to admit fault. He doesn't like to admit weaknesses or shortcomings.
I think the message that really is conveyed here is that no one is above the law, and that the process has played out, and it's going to now bring it to an end.
In a second and third case, a Trump-appointed judge this week temporarily blocked the Justice Department from releasing final reports from special counsel Jack Smith. The cases, both dismissed, involve the storage of classified documents and election interference with the January 6, 2021 attack on the U.S. Capitol. This week, the president-elect reiterated his belief that Smith was appointed illegally.
He was thrown off the case in disgrace. Why should he be allowed to write a fake report? It'll only be a fake report.
Special counsels are required to file summary reports. The U.S. Attorney General said he would release Smith's report on the January 6th uprising at the Capitol, making that public could hamper Trump's efforts to pardon those arrested.
If a lot of this comes to light, that a lot of this was planned and a lot of these activities were malicious and that they were criminal, he is giving people a free pass on criminal activity.
The fourth case deals with Georgia election interference. The prosecutor was removed due to an improper romantic relationship with an employee. So the case is at a standstill until it is dismissed or until another prosecutor is assigned.
I think the voters are actually hoping that this whole thing is brought to an end, and that now we can begin anew with a second Trump term.
And that term starts on Monday, January 20th.
It feels great.
Carolyn Persucci, VOA News.
Tomorrow now. Nice try, News. Nice try, News. Nice try, News. Sorry. I don't care if you like it or not. You like it or not. All these lives are coming out. It's a lot.
That okay, appreciate it. Anyone else? No? All right, you'll go down the hallway. When you leave here, you'll go to your left. It's not the next courtroom, but the next courtroom down. I think, is it open?
I just called it.
Okay, so the courtroom's open. Go in there, and we'll make sure it's all set. Okay, folks, thank you very much.
Thank you, Your Honor. Thank you.
That's my children one?
Yeah.
Okay. All right, so we got to get the video played for the next block. All right, so what's going to happen? Everybody can remain seated. I'm going to stand in recess and reset my brain and come back, and then we'll start the 2:00 block, folks.
To represent you. However, I am going to appoint counsel to represent you, and the court does appoint Jim Watts to represent you at all stages of the proceedings. Jim Watts is appointed to represent you at all stages of the proceedings. You may hire whomever you wish to represent you. Next item of business is to set this on the felony preliminary hearing control docket. This would be set before Judge Crum, and this would be on February 24, 2025 at 2:30, before Judge Crum on February 24, 2025 at 2:30. You do need to be present by Zoom hearing at that time.
Yes, sir.
And next item of business is to set appropriate bond. Mr. Stevie, what is your current address?
I don't have one.
Are you currently homeless?
No,
Where is it that you reside?
it's classified.
Okay. And
Thank you.
you, okay, recommendation for bond, Mr. Regier.
Your Honor, with all due respect, it is the state's understanding that the court has already issued orders concerning bond in this matter.
Okay, and what would that bond have been set?
To the best of my knowledge, Your Honor, 50,000 cash or surety.
And when was that set?
Your Honor, based off of the state's information within the last few days.
Okay, and who set that bond?
To the best of my knowledge, Your Honor, Judge Crum.
Charged with the fleeing, with the fact that he fled twice in the same incident. And no disrespect to Mr. Perlman. I know he's a good lawyer. He's involved in a lot of these cases before us. This defendant is clearly a flight risk. So respectfully asking for a tether house arrest, you could argue he's a danger too. While he's on bond, actually he's on warrant status in the other case. So that's what I have. That's what I have.
Okay.
And Your Honor, we're asking for a personal bond. I am representing him on the other matter, and that is set scheduled for next week. He's going to be arraigned on that matter, and a bond will be set. My client is he has a job. He works at Whitfield Renovations. He has 2 children who he supports. This is a incident that allegedly occurred in March of 2023. The warrant entry date was May 30th, 24. He never knew about this offense. He does have retained counsel and who handling both matters. As such, I don't believe him to be a flight risk. He's invested in this case. He wants to get these things in order. We're asking for a personal bond and the ability to allow him to work and provide for his family.
Okay. Two factors. The fact that he's retained you, Mr. Perlman, and if, given the age of the case, I am going to give him a $10,000 personal bond. I don't see a need for the tether. You have a reputation for having your clients in court on time. And so I think that's going to minimize any flight risk. So the $10,000 personal bond, no tether at this point in time. Probable cause January 22nd, preliminary examination January 27th, both in front of Judge Giles. Anything either counsel wants to put on?
Yeah,
Sorry?
I'm sorry, Magistrate. Yeah, the people only have one other thing to say. And again, I'll reiterate that I have a respect for Mr. Perlman, but he just told us that he's representing this individual in the other case where he's failed to appear twice.
I wasn't representing him at that time. He just retained me.
Yes, right. That's the sense I got. He just retained him and so on and so forth. So good point, Mr. Vincent. But I believe
Sounds
Mr.
good.
Perlman
Sounds good.
has been practicing a long time. He's going to have his client in court on time. So
Thank you.
my concern about him failing to appear is greatly minimized, and now Mr. Perlman's on the scene.
Thank you, Your Honor. You said the 27th for Judge Giles?
The January 22nd and 27th, probable cause and preliminary examination, 2227.
Thank you so much. Have a great day.
Okay, thank you.
You will.
All right. Hello, DDC.
Good morning, John. Good afternoon.
Hi, are you Demetrius Shaw?
Yes.
Okay, state your name again for the record, sir.
Demetrius Shaw.
Okay, Mr. Shaw has two cases, 250-551-8601 and 255-0551-7601. Miss Anna Meridian for the people, appearance first, please.
Yes, good afternoon, Your Honor. Anna Meridian, P75788 on behalf of the people.
And good afternoon, Your Honor, and to your staff. May it please this most honorable court, Mohammed Nasser, P74485, appearing on behalf and with Mr. Demetrius Shaw on both matters.
Okay, hold on, Mr. Nasser. Hold on, Mr. Nasser. What's your P number?
74485, Judge.
74485.
Correct,
And
Judge.
Madam Prosecutor, what's your P number?
75788.
75788. Okay, go ahead, Mr. Nasser. I'm sorry.
No, not at all, Judge. I appear on behalf of Mr. Shaw on both matters, who's already identified himself from the Detroit Detention Center. Your Honor, Mr. Shaw would waive the formal reading of the information of the complaint on both matters. Stand mute. Humbly request the court to enter a not guilty plea on his behalf.
The court with a not guilty plea on behalf of Mr. Shaw on both matters. Madam Prosecutor, argument as to bound on both cases. I assume, at least on one, you're going to be asking for a remand?
Yes, on the homicide, the people would be asking for remand. On the assault with
What's your
intent,
argument?
Your Honor, the arguments go together. So if I may.
Sure.
And on the assault with intent to murder, the people would be asking for $1 million cash or surety, no 10%. If the defendant posts bond, then a GPS tether and house arrest. The reason I'm asking for such a high cash bond as well as remand on the homicide is because this defendant is involved with a gang. That gang has been involved with trading shootings back and forth for multiple months in the city of Detroit. The assault with intent to murder is only one of the instances in which the defendant fired shots, hitting someone. The charge, there are other cases under investigation and cases pending. The assault with intent to murder charge stems from a shooting in May 2024. Very early in the morning, the defendant and a number of his friends went to go look for someone who was in an opponent gang. They had a vehicle description and they saw a vehicle matching that description, specifically a gray Tesla, figured that had to be the person they were looking for, and then followed that car and shot the occupant, who was a completely innocent person, not gang related in any way, hitting that man multiple times. They then, in the homicide case that occurred on July 7th, on July 6th, the defendant and several of his friends were discussing in Instagram group chats, looking for specific people they were trying to shoot and kill. The defendant used the word hunt. He and his friends indicated that they had to go deep to this party, that they had to bring switches, which are pistols or rifles that are modified with a button or a switch to take them from semi-automatic to fully automatic. He and 5 of his friends and other gang members went over to Rossini. They didn't park on Rossini. They parked 3 streets north of Rossini and hopped fences for several streets until they got to the backyard of a house that was across the street from a block party that was happening. There were multiple people, probably hundreds of people based on the witness statements and the video that we have, that were out there enjoying their evening, having a good time, when the defendant and 5 of his friends opened fire on that block party. They fatally shot 2 people, a young man and a young woman, and they injured with gunfire 19 others. So for that reason, the people believe that there is a very high danger to the community if this defendant is to get out on the assault with intent to murder, and also on the homicide and assault with intent to murder at the block party case. And people believe the likelihood of conviction is high in both cases. The defendant did make admissions in both cases to being there and participating in the events. He admitted to discussing and planning these things with his friends ahead of time via social media returns. Also, the defendant's phone mapping places him in the area at both scenes at the times of the shooting. So the people believe, with danger to the community and with the likelihood of conviction, the bonds would be appropriate in this case.
Mr. Nassar, your response?
Judge, my response would be, first and foremost, I thank the prosecutor. She got me over some documents that I'm able to review very quickly. At the end of the day, Judge, what we have to understand is, 1, there's a presumption of innocence. 2, while certainly the allegations are the most significant that this court can view, Judge, these incidents occurred back in May and July of 2024. So you're talking some 6 and 8 months removed from now. If this individual was as egregious and or as dangerous and or such a flight risk, then certainly the police could have done something in order to detain him back in May or back in July. Certainly they have the ability to investigate, but having these type of allegations with phone mapping and everything else, he was found. He wasn't running, Judge. This is a Detroit native. He's 19 years of age, no prior record, gainfully employed through Amazon. Most importantly, Judge, he has retained counsel. This court is aware of myself and my firm. People don't hire Mohammed Nassar if they're going to run. The question presented here is based upon the allegations. I know the knee-jerk response or the automatic response is a remand. I'm asking this court to consider not giving him a remand based upon the fact that these matters are at least 6 to 8 months old, and my client hasn't run anywhere. He was located at his father's house, and he's ready to address these matters. And any suggestions or statements of admissions show that this is an individual that wants to resolve the matter. If an individual made it an alleged admission, which I haven't seen yet, then that speaks to his desire to address, not to hide and or to run. So in light of the same, Judge, I'm asking this court to give a bond. It's going to be a high bond, I know it, but I'm asking this court to consider a $300,000 bond, house arrest, GPS tether. Certainly that creates a substantial hardship for the family, but it is a bond that at least can be considered. Certainly he's not prepared to post that at this point, but I'm asking this court to consider same based upon the circumstances. Thank you.
Mr. Nassar, he did run in one instance. He ran to you. He ran to retain you in this matter. So he's not a flight risk, but he did run to you. Absolutely. And well, you have well argued on behalf of your client. But in light of Madam Prosecutor's arguments with respect to the homicide case and 2 people being dead, and the assault with attempted murder case, based on Madam Prosecutor's argument and representations, I do find by clear and convincing evidence that Mr. Shaw is a danger to the community. And for those reasons, I will remand him in the murder case in the custody of Wayne County Jail and will grant him a $1 million cash surety bond on the other case. While this case is pending, no contact with any of the complaining witnesses in both cases. And he's not possessing handguns, firearms, other dangerous weapons. Mr. Nassar?
Yes, Judge.
For the case, he has $1 million bond. The bond redetermination will be Monday, January 13th, 9 a.m. in front of Chief Judge McConaughey.
Yes, Judge.
Okay. And the $1 million bond case, the AWIM case, probable cause will be January 17th, preliminary examination January 24th. On the remand case, probable cause January 21st, preliminary examination January 27th. That case is in front of Judge Sabri. The AWIM case is in front of Judge Jefferson. Is there anything else either counsel would like to put on the record?
Your Honor, would this court be willing to sign a protective order for discovery, or should we wait till we get to the next court for that?
Wait till the, I believe, I'm not even sure I have authority to sign that. So I would prefer that you get to probable cause to do so.
All right, thank you. Nothing else.
Judge, I would just ask this court, you said the first PCC for the AWIM case was the 17th and the murder case is the 21st?
Correct.
Thank you so much, Judge.
Okay, both of you have a good weekend.
You too, Judge. Thank you.
Thank you all.
All right. DDC, can we bring out Mr. Ganesh and then Mr. Blackwell?
Their routine. Blackwell routine. Ganesh.
What's your name, sir?
Zachary Ganesh.
All right, this is case number 250-551-9401. People Michigan versus Zachary Ganesh. Appearances, please.
Jennifer Douglas for the people, P72748.
May it please his honorable court, Vassal Johnson II, P72130 on behalf of Mr. Ganesh. He's present on Zoom here. As
What's
the
your P
rank,
number, Mr. Johnson? Hold on, Mr.
Sorry.
Johnson. What's your P number?
72130.
Okay, go ahead, Mr. Johnson.
As to the arraignment, waive from a reading of the information and stand mute.
Over to not guilty plea on behalf of your client. Final recommendation, Ms. Douglas.
Your Honor, Mr. Ganesh, the people wouldn't object to a $25,000 personal bond. We would ask for an order of no alcohol and no controlled substance except as prescribed by a medical professional during the pendency of this case. We'd also ask for an order of no driving. Here, there's an allegation that Mr. Ganesh displayed signs of intoxication, although it's signs of drug intoxication. And Your Honor, there was a car crash with Mr. Ganesh's vehicle described as being stopped on the wrong side of the street when police responded to the crash. So we do have some concerns for safety. As far as priors, the only thing I saw was a 7911 case that was successfully completed. That one was a possession case. So we do have some concerns about possible use of substances and driving during the pendency of this case. That's why we're asking for the order about no alcohol and no controlled substances, and why we're asking for the no driving order, but no objection to 25,000 personal.
Well, the preliminary blood test indicated 0 alcohol, so I don't see a need. He did do a blood draw. I'm pretty sure you haven't gotten the blood results back yet since it was 2 days ago.
That's correct, Your Honor. However, his eyes showed signs of being under the influence.
I understand that, and that's why part of the order will be no possession or use of drugs. I'm not at this point ready to deprive him of driving. And what was the dollar amount of personal bond you said?
25,000.
Okay, 25,000 on a personal bond for Mr. Ganesh. As I indicated, no drugs or illegal substances at this point. At this point, I think it's premature. We're absent any blood draw results to address any driving privileges he may have. Like I said, he blew a preliminary blood test of 0. That's not to indicate that he wasn't under the influence of anything. It's just a little bit premature at this point. So $25,000 personal bond, no drugs, probable cause January 22nd, plenary examination January 28th. And I was speaking on behalf of you, Mr. Johnson. I take it there's no objection to this?
No, Your Honor, you did a great job. Just kidding. No objection, Your Honor.
I needed that, Mr. Johnson.
We all
okay.
did,
Both dates are in front of Judge Giles. Step aside. You have a good weekend, Mr. Johnson.
Thank you. You as well.
Thank
Ms.
you, Your Honor.
Douglas, can you
Okay.
please forward me the discovery?
You know what? I actually do not have access to that because I work for the city, but someone at the
Oh.
prosecutor's office will do that for you.
Okay, sounds good. Thank you. Have a good day.
All right, now, Mr. Pope, last but not least, is this Mr. Blackwell?
Yes. Oh,
Yes. Hi, is that? All right, state your name, Mr. Blackwell.
Brian Blackwell.
All right, this is case number 250-551-8101. People said Michigan versus Brian Blackwell. Appearances, please.
Thank you, Magistrate. Steve Vincent for the people.
Your Honor, may it please this honorable court, Larry Polk on behalf of Brian Blackwell, who is present by way of Zoom. My P number is 48164. Mr. Blackwell, will you state your name?
Brian Blackwell.
At this time, Judge, we waive the formal reading of the warning complaint. My client would stand mute.
All right, the court will enter not guilty plea on behalf of your client. Mr. Vincent, your bond recommendation.
Magistrate, it's as you can see, as well as Mr. Polk knows, this is a bribing and witness intimidation case. I'll get into the particulars just very briefly, but I am going to be asking for a $250,000 cash surety with monitorization. It's just some preliminary matters. The defendant does have 2 existing warrants out for his arrest. He has a failure to appear out of Dearborn for a disorderly conduct conviction where he failed to appear for probation, and then a show cause hearing was set up where he failed to appear. He also has a warrant out of 16th District Court right now for a failure to appear on a retail fraud case. Now, in this particular matter, the reason why we're asking for what we're asking for is the closest thing, let me just start this way. The closest thing that I could find under MCR 6.106 to potentially get a remand for this client was the extortion element. But the extortion element is connected to kidnapping. And clearly there isn't kidnapping here. So hence, I can't ask you legally for a remand. But what I can do is ask you for a high cash bond that is hopefully unattainable for this defendant for the protection of the individual that this defendant tried to bribe in court in order not to testify.
How did he try to bribe the complaining witness?
Well, verbally, I guess, as well as the idea that he ended up stuffing money into her pocket, all the while they were in the courthouse in a hall. And the individual,
Mr. Blackwell.
Sorry about that.
This is the last time and first time I'm going to warn you. Please don't interrupt myself, Mr. Vincent, or Mr. Polk.
Sorry about that. I thought you said I was muted. I'm sorry.
Okay, go ahead, Mr. Vincent.
the interaction was caught on video because this ended up occurring in the courthouse. And the reason why the bribe allegedly took place was his brother is being charged in a non-fatal shooting against this same complaining witness. The bribe was for the complaining witness not to testify against his brother. The individual that he attempted to bribe, who's going to be testifying against her brother, ended up apparently getting offered $5,000 not to testify. But she also got money that day involuntarily, where this defendant allegedly ended up stuffing money into her pocket. Now,
Okay, let me pause you right there, Mr. Vincent. Let me pause you right there.
Sure.
Did the complaining witness return the money?
What she did was she ended up contacting the officer immediately. This all happened within a short amount of time, magistrate. So she ended up going back into, I think, the victim's area because court was in session regarding this defendant's brother. She ends up going back to the protected victim's area, contacts an officer, and lets that officer know exactly what ended up transpiring.
Okay. My second question is,
yes.
Were there any threats of physical harm?
I don't believe there was particularly any threats of harm to herself or anybody else. The money that was being exchanged made this individual feel very unsafe. And she ended up telling the police officer she feared for her safety as a direct result of what this defendant ended up doing. I mean, we have to understand this for what it is. His brother's being charged with shooting that individual.
I understand that. I understand that, Mr. Vincent. And the reason I'm asking those pointed questions was exactly to your point. Is this bribery or is this more intimidation? Or is it both?
I think it's both, quite honestly. I think it's both. The bribery was clear and present by the fact that he verbally ended up saying as much and giving her as much. But I believe, coupled with the fact that his brother is standing trial for shooting this individual, and this individual, the complaining witness, fearing for her life, I think it could be shown that there was intimidation that was going on. So based on all of that, and I understand Mr. Polk's involved, and this defendant needs somebody like Mr. Polk to defend him in this kind of matter. There is a certain level of flight issue. There's a big level of danger issue. He's already been positively ID'd as the offender here. The interaction allegedly was captured on video, so we think there's a high likelihood of conviction, and we do want an unaffordable bond. I mean, it's clear that he has money because he was trying to bribe her, I think with how many thousands of dollars. So it needs to be unaffordable to be able to protect this complaining witness. So that's why we're asking for the high cash with monetization.
Well, and Mr. Vincent, it depends on what you define as money. The report indicates he put $100 in a pocket.
He also offered her $5,000 not to testify.
Okay. Unless it was a layaway plan or something, I don't know.
Well, he told
go ahead, Mr. Polk.
he got her WhatsApp app or whatever in order to
WhatsApp app is WhatsApp.
Whatever.
Cash app.
What cash,
Zelle.
what, when, where, how,
Whatever.
I don't know. You know what I'm talking about.
Okay, you know what? No, I had to clarify for myself. But go ahead, Mr. Polk.
Okay, so Judge, we don't set bonds, and I'm sure that this court doesn't set bonds on some things that are not seriously looked at as a part of the record. In this particular case, and the information is being provided, you've asked a poignant question. Is there an element of intimidation? No, there's not. There's nothing. She didn't report no intimidation. To try to color it so that you can get the bond that you want is not how we go about it. We look at bonds and look at the probability of flight, and then we look at the probability of being some type of threat to the community. Even with this case being allegations of a bond, not a bond, of bribe someone to not testify, that does not have an element of intimidation. It does not say, hey, if you testify, this is something that's going to happen to you or someone that you love or respect or whatever. So that's just not there. My client is 34 years old. He's a lifelong resident of the city of Detroit. He has substantial contacts with family members here in this community. He's a high school graduate with some college and has graduated from 2 trade schools. he has minimal criminal contacts. He has in 2012, he had a receiving and concealing. I don't know anything about this retail fraud out of Macomb District Court. And there's an allegation that there is a disorderly conduct out of the city of Detroit, which I have no information on. I don't know when it happened. I don't know any of the particulars in reference to it. But what I do say is in neither one of those do you have anything that's assaultive in nature. And so, again, looking at my client, he's the father of 3 children. 2 of those children reside with him. The other comes over frequently and spends a tremendous amount of time with his father. In this particular case, I absolutely believe that the goals of making sure that my client not have any contact with this particular individual can be met, because all he has to do is be told not to have any contact with her, and that is sufficient. And the fact that he has retained counsel, he has not me just representing him on this matter, he has my counsel in reference to how we need to move forward with this particular case. And so I believe that the prosecutor is asking for something that is unreasonable, and I urge this court not to have some type of $200,000 bond that hopefully my client can't afford. I don't think that's how we should move forward in terms of this.
Could I respond to that really quickly? Just really quick.
Very, 1 minute, 1 minute.
Okay, just to correct the criminal history. He does have felony drugs as well as the RCSP motor vehicle. He had the disorderly, and then he has the retail fraud. And there's flight. I mean, with all due respect to Mr. Polk, he just shows it because he has multiple warrants out. In terms of the intimidation, she felt in fear as a direct result of what this defendant was doing. When you have an individual giving you or attempting to try to give you money in order not to testify against another individual's brother, who she ended up sustaining a bullet from, I do believe that there's a level of intimidation.
I get that. I get that. I get that.
Okay.
And that's why the charge is bribing, intimidating, interfering with so on and so forth. Now, I've heard arguments from both counsels, well argued, and Mr. Polk, kind of the closest person that was kind of reading my mind today in terms of whether is this interfering with the case or is this intimidation, excuse me. And yes, I'll give, the allegations are I'll give you $5,000 and place $100 in her pocket or whatever. I can understand why the complaining witness, given her age, would feel somewhat fearful. But I see nothing on the record and nothing in the report that indicate that she was in threat of physical harm. Is it witness tampering, interference? Yes, clearly that. But I don't see anything where the complaining witness was actually when any threats implied or actual threats to her physical safety. The implication is like, if you just keep your mouth shut, I'll give you money. One could read into that what they want to. So that goes to Mr. Polk's point. I'm going to give him $100,000 personal bond. I thought about, I was flirting with giving him a tether. And because there was, based on my just stated with respect to any actual or implied physical threat to her, I'm not going to give him a tether at this point. Because he has retained Mr. Polk. I've known Mr. Polk for several years, well-respected attorney. He is a great attorney and a great advisor. I'm pretty sure he will have his client under control and have his client follow his advice in terms of the no contact provision. And that no contact, sir, means just that: no phone calls, text messages, emails to third party, handwritten letters or notes by pigeon bird. I don't care. No contact. Is that clear?
Yes.
Also, while this case is pending, just to assure you're not to possess any handguns, firearms, or other dangerous weapons.
Never.
Probable cause January 21st, preliminary examination January 27th, both in front of Judge Jefferson. Is there anything else either counsel wants to put on the record?
Nothing else, Your Honor.
Okay.
No, thank you.
Okay, step aside,
Thank
sir.
you.
All right, straight down the list, DDC. Who do we have visiting here in my waiting room? What's your name? Felipe Dawson. Can we get Terrell Hendricks as well? Can Mr. Hendricks join Mr. Dawson, please? Thank you. Okay, both of you gentlemen state your name for the record.
Gerald Hendricks. Felipe Dawson.
All right, this is case number 250-551-7501 and 7502. People State of Michigan versus Felipe Dawson and Terrell Hendricks. Appearances, please.
Good afternoon, Lisa Coyle appearing on behalf of the people.
Good afternoon. Mr. Reagan.
Sorry, Judge. Good afternoon, man. Please, this most honorable court, Philip Reagan, P57156, on behalf of Mr. Dawson and Mr. Hendricks. We would waive the formal reading as to both gentlemen stand mute. They have been advised of their rights. Good afternoon, Ms. Coyle, to you.
Good afternoon.
All right, on both of your clients, I will enter a not guilty plea. Mrs. Coyle, your bond recommendation for both of these gentlemen?
As to Mr. Dawson, it looks like he has a couple priors, but they're old. The oldest and most assaultive being a carjacking back from 1997. The last thing I see is a gun case from 2018. This was a search warrant execution. This is non-assaultive. There was all the indicia of sales in that house. He is the described seller in the search warrant. No objection to a $25,000 bond as to Mr. Dawson. As to Mr. Hendricks, we saw him here yesterday. He had a couple of retail frauds in which you gave him a $10,000 personal bond on each of them. One of them only had a capias on it. No objection on that matter, Your Honor, as well to a $20,000 personal bond.
$25,000 on Mr. Dawson and $20,000 on Mr. Hendricks?
That's correct.
Okay. The court will adopt the recommendation of the people, $20,000 personal bond for Mr. Hendricks, $25,000 personal bond for Mr. Dawson. For both of you gentlemen, you're not to possess any handguns, firearms, or other dangerous weapons while this case is pending. And hold on one moment for your court date. Mr. Hendricks, for you, sir. Probable cause January 17th in front of Judge Kevin Robbins. Preliminary examination January 24th. It looks like in front of Judge. House? Let's see. Is that correct? Who's the other judge on this one? I know it's Robbins, but who's it?
So this is Robbins.
Yeah, but who's the criminal exam judge?
When the exam.
Yeah, so we just give them one day, Mrs. CCW.
No.
But it's both of them right here.
I know he got the dates, but he's not assigned an exam judge yet.
He needs an exam judge, Judge.
I'm trying to understand what you mean, need an exam judge.
Give me one moment, please.
So this is when.
Low light.
Okay, my apologies. Mr. Hendricks, probable cause January 17th, in front of Judge Kevin Robbins, preliminary examination January 24th, in front of Judge Giles. Mr. Dawson, you're not to possess any drugs, handguns, or other dangerous weapons. Probable cause January 21st, preliminary examination January 28th, both in front of Judge Giles. Step aside, gentlemen.
Hey, this way.
What's your name?
Daniel.
All right, Mr. Daniel, you have some traffic matters which you failed to appear in court for, sir. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside those arrest warrants. We approach the bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have a right to an attorney. If you can't afford an attorney, one will be appointed on your behalf. The tickets are P118 7918. Driver license suspended. P14137401. Expired plates. Driver license suspended. P930513. No insurance misdemeanor. Driving a registered motor vehicle. Improper plates. And P932028. Failed display of valid operator's license on person. In each of these misdemeanor matters, sir, you were given a personal bond, no dollar amount. Pretrial will be February 13th in front of Judge Millicent Sherman. And now to your main matter, calling case number 250-551-9001, Coos State of Michigan versus Truman Daniel. Appearances, please.
Thank you, Magistrate. Steve Vincent for the people.
Your Honor, Phil Wright on behalf of Mr. Daniel waived the written stand mute. He's been advised of his rights.
Court of not guilty plea on behalf of Mr. Daniel. Bond recommendation from the people.
Just based on circumstances, I actually have a number of drug cases this afternoon. Mr. Daniel's case is the least of the three. So regarding that, and because it's not assaultive, he's not on probation or parole, I'm not going to be objecting to a personal bond at this time.
No objection, Judge.
$5,000 personal bond, Mr. Daniel. While his case is pending, you're not to possess nor use any illegal drugs. Is that clear, sir?
Sir.
Give me one moment for your court dates. Probable cause January 22nd, preliminary examination January 28th, both in front of Judge Giles. Step aside, sir.
How much was the bond amount?
$5,000 personal.
Thank you.
You're welcome. What's your name? What's your I can't hear over the background. Dorian Alexander. Okay, I got you. All right, Mr. Alexander. This is case number 250-551-8201. Peace and Michigan versus Dawanya Alexander. Appearances, please.
Jennifer Douglas for the people, P72748.
Philip Reagan on behalf of Mr. Alexander, Your Honor, waive the reading, stand mute. He's been advised of his rights.
Forward and not guilty plea on behalf of Mr. Alexander. Bond recommendation. Ms. Douglas.
Your Honor, Mr. Alexander, the people are going to ask for a bond of $200,000 cash or surety with tether house arrest for the following reasons. We believe that Mr. Alexander is a danger to the complaining witness, but also to the public. Mr. Alexander is currently on 2 different HIDA probations, Your Honor. He's on one HIDA probation for receiving, concealing stolen property, motor vehicle, and he's for the other cases receiving, concealing stolen property, $20,000 or more, and for unlawful driving away of an automobile. One of those he started probation in April of 24. The other one he started probation October of 24. And while on those HIDA probations, he's allegedly shooting at somebody out in public. Your Honor, here there were 12 spent casings recovered. Multiple people heard that there had been multiple shots fired, and we have an individual who was shot in the thigh. So we know that the shooting happened, Your Honor, through investigation of looking at a lot of green light video and security video, and using license plate readers. There was an ability to eventually track down who Mr. Alexander was, and he eventually was tracked down as far as them being able to identify him, Your Honor. And so at that point, he is alleged to have admitted that he went ahead and did shoot at this person. He provided 2 possible motives. One, it was in retribution for the complaining witness to have allegedly set somebody else up. And then also the other explanation was supposed to be that perhaps the complaining witness was threatening his mother. So, Your Honor, this is something then that was premeditated, not done on impulse without thinking, but something that was thought through, something that was targeted. And when we have somebody who is on 2 different HIDAs, we have to say that this is a person who's had to explain to them the impact of a criminal history, and yet we have him allegedly doing this. So, Your Honor, when we have shooting outside, anyone could get hurt. Fortunately, only one person got hurt and they aren't dead, but someone could have been murdered. It could have been multiple people shot, including children. And so we're asking for that higher personal bond because we think it's what is required to protect both the complaining witness and the public here with Mr. Alexander. He's already under supervision. So we are asking for the higher bond to ensure the safety. $200,000 cash as surety, tether house arrest.
Reagan?
Judge, I do understand the people's concern, Ms. Douglas's concern. There are probations, a height of probation. I think it's non-assaultive matters. We have a situation where we talk about video, we talk about green light, we talk about several individuals, Judge. We talk about folks getting in and out of a car. But the one thing we talk about is an actual confession. Now, I don't for a minute, Judge, necessarily think that Mr. Alexander actually told the police certain things. I think that's one thing, Judge, we look at in terms of the investigator's report, whether or not that's going to be something that's obviously going to be challenged later, whether he said what they said in the report. I don't think it happened that way, Judge. I think a lot of times these reports are twisted or certain statements are twisted because it's always so convenient for somebody to make an admission. Yeah, I did this, this is why I did it. And no, I don't think so, Judge. I think right now we're at the early stage. I don't take a lot of weight in that aspect of it now. When you talk about the other aspects, and that's another story. Statements, I don't take a whole lot of weight to, Judge. I don't know if there are any eyewitnesses that identify or point the finger and say, hey, Mr. Alexander is the one that actually pulled the trigger. No. So, Judge, I think what's going to happen is we're going to get to court. Some of this stuff has to play out. But for right now, he's being monitored on probation. As Ms. Douglas said, he's on heightened probation. I don't know what's going to happen with that. But as terms of this case, Judge, I'm asking for a higher personal bond, obviously, whatever monitorization the court wanted to do to ensure they keep a track of where Mr. Alexander's whereabouts are. So, Judge, you know, I don't think there's a situation now where he's on tether or anything of that nature, because tethers can track people. Tethers can put you in locations. So if he's on a tether, Judge, and he gets out of hand, you're going to know exactly where he is at all times. So I'm asking the court for the monitorization, but I am asking for a personal bond on his back.
Is your client employed or in school?
Judge, he owns a clothing line. He's self-employed. He owns a clothing line. He's also in school.
19,
Judge.
wait a minute. He's 19 and 20 years old and owns his own clothing line?
That's correct, Judge. That's correct. But he's also in school too, Judge. He's also, what'd you say?
I said, go ahead. Finish your argument.
He's also in school, Judge. He's working on getting his high school diploma as well. So, owns his clothing line, Judge. He's 19. He's being monitored. He does have a child. He lives in the area. So I don't think he's a flight risk, Judge, at all. I think a lot of the stuff in the report may be a little circumstantial, you know, but I'm asking the court to give him that benefit because he is being monitored. If you put a tether on him, you know exactly where he is. If he steps out of line, the tether's going to go off and start pinging and binging and doing all the stuff it does. So therefore, you'll know where he is at all times, Judge. So I'd ask the court to consider that.
Is he in school online?
He is, Judge. He is in school, working on his diploma. He's working online from home. So even if the court said house arrest, there's no reason for him to leave out the house because he can work on his high school diploma in the house because he's going to school online.
Okay, I think that's probably the least restrictive means here. I'm going to give him $100,000 personal bond, GPS tether, house arrest. So he can't continue school and do what he needs to do. He can't possess any handguns, firearms, other dangerous weapons, no contact with the complaining witness in this matter. On the one hand, sir, I can applaud you for having your own clothing line at such a young age. But by the same token, somewhat disappointing that given your age, you don't have your GED or high school diploma. The tether will allow you to complete both in a timely manner. And as the defender's office likes to remind me, this is the least restrictive means to handle these type of situations.
Honor, just for the record, we don't think that the assault with intent to murder, that 100,000 personal is going to be sufficient. I just want to put that on the record. We don't think that that is what is going to reasonably ensure the safety of the public, since he is allegedly confessed to trying to shoot a person in public. So I just want to put that on the record.
Okay, duly noted. Probable cause January 22nd, preliminary examination January 27th, both in front of Judge Giles. Step aside, sir.
Thank you, Honor.
What's your name, sir? Mr. Green? Mr. Green, you have some traffic matters which you failed to appear in court for, sir. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say will be used against you. You have the right to an attorney. You can afford an attorney. One will be appointed on your behalf. The tickets are SP 11114881. Driver license expired. Ticket 19-441-5691. No operator's license in person. Ticket P1326029. Driving license suspended. Unregistered motor vehicle. Ticket P1437548. Expired plates. Ticket P1437550. No insurance, misdemeanor. Proper plates. Driving license not valid. Ticket P1465939. No insurance, misdemeanor. Driving license not valid. Improper plates. Ticket P1616889. Driving license suspended. No insurance, misdemeanor. Improper expired plates. In each of these misdemeanor traffic matters, so you're getting a personal bond, no dollar amount. Pre-trial, February 14th, Valentine's Day, in front of Judge Perkins. Now to your main matter, calling case number 250-551-8501. Peter City, Michigan versus Ronell Green. Appearances, please.
Thank you, Magistrate Steve Benson for the people.
Great. On behalf of Mr. Green, Your Honor, waive the reading, stand mute. He's been advised of his rights.
Forward on not guilty plea on behalf of Mr. Green. Bond recommendation from the people.
Magistrate, we're asking for a $250,000 cash bond. We're also asking for tether as well as house arrest, not to the location where this incident took place. This defendant is being charged with the controlled substance 50 to 449 twice over. He's being charged with the meth count as well as the maintaining a drug house and 5 gun charges. This defendant was just convicted about 6 months ago for a controlled substance offense. He's on probation right now. In that case, there was an overdose death. What the prosecutor's office is doing right now is investigating that overdose death to see whether or not there was a delivery causing death that this defendant is going to be charged with. The APA, Miss Merrigan, who was earlier appeared on that homicide case, this is actually her case. I spoke with her for about 20 minutes this afternoon. The request comes from the prosecutor's office regarding the high cash bond, as well as tether and home confinement. This defendant's priors are substantial. He has the home invasion first degree, as well as the felony.
Homicide, right? It's a homicide, right?
Because the individual involved in that home invasion subsequently died. That actually was brought and he was convicted after the fact. So he has the homicide, the felony home invasion first degree. As soon as he gets out of prison, he ends up getting another felony conviction for an attempted B&E. He most recently had an OWI. But on top of the fact that he's on probation right now for the controlled substance, this house was the same house where the other incident took place. And as you can see, based on everything that was found in the house, and you can correct me if I'm wrong, we're dealing with over 110 grams of cocaine, over 192 grams of methamphetamines, 50 grams of fentanyl, over 20 grams of heroin. But I think what's most telling is there was a press that was found. And you know, the only reasons why presses are involved to handle high quantities of drugs. So we find this defendant to be a clear and present danger, not just because of his history, not just because he's on probation, not just because of the homicide that he had to spend time for, not because he continues to do this while he's on probation, but the quantity involved.
The sheer quantity of this.
Yeah.
And what was the dollar amount you're asking? You said 250,000?
That's correct, Magistrate.
Okay, Mr. Reagan?
Judge, it's guns, it's drugs, it's guns, it's drugs. There's no assault here. It's no assault. It's all non-assaultive stuff here, Judge, all non-assaultive. We talk about, and Mr. Polk, I think, brought it out earlier. We talked about a 2-pronged test. We talked about flight risk. Well, you know, Mr. Green's not a flight risk, Judge. He's on probation now. He reports his probation officer. You know, he's back at the same house as Mr. Vincent said that allegedly was involved in the first situation. So he's not going anywhere. He's not running anywhere. Now, in terms of a danger, Judge, all of this information you have all this information in front of you. It's got to go through the process. It's going to go to a PCC exam. It's going to go through a trial process. We're just at arraignment right now, Judge. If nobody's dead, nobody died in this particular situation that we know of. He's not charged with any type of death in this case. Just possessing things, you know. So I'm asking the court to look at that aspect. We're not punishing right now. This is not about sentencing. It's not about trying to say, oh, he's a bad person. Oh, he made a mistake. He went back to the same place, did the same. It's not what this is about. It's simply about setting a bond. The case is going to proceed. It's not getting dismissed today. And I'm just saying to the court, he's not a flight risk. I don't think he's a danger. If the court gave him a high personal bond, he's going to come to court. He's going to fight his case. And that's all I'm asking the court to do, Judge, in this case, is give him a high personal bond.
Okay, just a question, Mr. Reagan. Is he employed?
Judge, he does home improvement. And he works, Judge, really 9 a.m. to 7 p.m. He's out every day. And now, Monday through Friday, he does on the weekend. Now with the snow coming.
Let me ask a follow-up question. Is he self-employed or does he work for somebody?
Mr. Green, can you answer that question? Are you self-employed?
I work for someone.
How long did you work for them?
A little over 6 months. I work for 2 companies.
6 months?
Well, over 6 months, sir.
What type of home improvement do you do?
Anything dealing with a house. I do roofing, I do drywall, I do masonry work, painting. I specialize in painting and drywall.
How many days a week do you work?
Monday through Saturday.
Just a couple of things. I mean, I do find it a little ironic that he was.
No. I've heard enough. I'm going to adopt the recommendation of other people. $250,000 cash surety. And the reason why I find him a danger to the community is Mr. Vincent's point, the sheer quantity of that. I want to just tell the house arrest. While this case is pending, you're not to possess any handguns, firearms, or other dangerous weapons. Like I said, I was persuaded of Mr. Vincent's argument that the sheer volume of this indicates that he is a danger to the community, turning over that volume and giving that level of equipment. And then when queried about his work history, it's kind of sketchy at best, 6 months. He's working 7 days a week. He works for 1 or 2 companies. I didn't get concrete nor persuasive answers as to consistent, steady employment.
Judge, he didn't babble. He gave you the straight answers. You asked. He didn't linger on.
He did.
Put him on the tether. Keep him at home. If you don't think the employment is legitimate, Judge, just keep him at home. Then. Put him on house arrest.
No, most people I can ask what where you work or whatever. They can tell me right, boom, 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 just like where they live and so on. And so on and so forth. His answers were kind of hazy at best.
He's in the DC, probably a little nervous. He's getting ready for.
You know what, Mr. Reagan. I'm
just saying,
Mr. Reagan. I hear you. Like I said, I find him a danger to the community for the reasons stated by Mr. Vincent. Bond redetermination will be Monday, January 13th, 9 a.m. in front of Chief Judge Mechanical. Thank you. Probable cause January 23rd, preliminary examination January 29th, both in front of Judge Taylor. No illegal drugs and no handguns or other dangerous weapons. Step aside, sir.
Thank you.
What's your name? Eric Johnson. All right. This is case number 250-551-7801.
He said Desmond Johnson.
Thank you for correcting me. I heard Eric Johnson.
I'm telling you, he said Mr. Desmond Johnson, Your Honor.
All right. Thank you. I stand corrected.
Are you Desmond Johnson?
Yes.
Okay. I heard Eric. Maybe I need my ears cleaned out. Forgive me. Mr. Desmond Johnson, you have some traffic matters which you failed to appear in court for, sir. As a result of your failure to appear, warrants for your arrest were issued. Court's going to set aside those arrest warrants for your personal bond. And these misdemeanor matters that carries a maximum penalty of 93 days in jail and or a $500 fine. Oh, he's on here twice. That's why. Yeah, right to the attorney. You can afford an attorney. One will be appointed on your behalf. And the right to remain silent. Anything you say can and will be used against you. Tickets are U66145423. Loitering in a place of legal occupation. And ticket U66141823. Narcotic drug related violations. You're in a personal bond, no dollar amount. Pre-trial, Valentine's Day, February 14th, in front of Judge Williams. Now to your main matters. Case number 250-551-8801. Peter City, Michigan versus Desmond Johnson. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
On behalf of Mr. Desmond Johnson, waive the reading stamp mute. He's been advised of his rights, Judge.
Court a not guilty plea on behalf of Mr. Johnson. Bond recommendation, Mrs. Coyle.
Your Honor, this is a much lower level drug operation. This is the execution of search warrant. There were 7 pills, 6 grams of fentanyl, and 14 grams of cocaine as packaged. No objection to a $25,000 personal bond. I do note that all his priors are typically drug convictions and a gun.
No objection, Your Honor.
$25,000 on a personal bond, Mr. Johnson. While his case is pending, you're not to possess nor use any illegal drugs. Probable cause January 22nd. Preliminary examination January 28th. Both in front of Judge Giles. Step aside, please. What's your name? Okay, you broke out on me. Repeat that.
Wayne A. Irving Sr.
All right, is there De Niro Irving with him? Can you bring them both out?
At this moment.
One and two, yeah.
All right, gentlemen, state your name again for the record.
Wayne A. Irving Sr.
Take your mask off and speak again, please.
De
Niro Irving?
Yes.
Okay, so case number 250-551-8901, 8902. People State of Michigan versus Dwayne Irving and De Niro Irving. Appearances, please.
Respectfully on both individuals, Steve Vincent for the people.
And Philip Ray on behalf of De Niro and Dwayne Irving, waive the reading stamp mute to both gentlemen. They've been advised of the rights, Judge.
Court with a not guilty plea on behalf of both clients. Bond recommendation for both, Mr. Vincent.
Magistrate, regarding Mr. Dwayne Irving, defendant number 1, and this is not just based on the allegations, but the charges. Regarding Mr. Dwayne Irving, we're going to be asking for a $20,000 cash surety. We're asking for monitorization. He's charged with the controlled substance 50 to 449. Regarding Mr. De Niro Irving, we're going to be asking for a $20,000 personal bond. We're also going to be asking for monitorization. The reason, as you can surmise, why I'm asking for the cash on this is because in this particular case, Mr. Dwayne Irving was in this house located by and having on his person some of these narcotics, but the narcotics totaled 132 folds of fentanyl. 132 folds of fentanyl over 470 bags of crack.
Didn't have any of that. Irving, don't interrupt me again. Mr. Irving, don't interrupt Mr. Vincent and myself again. I want to give you a high enough cash bond where you don't have to worry about talking again.
I apologize, sir. I apologize, John.
Okay, go ahead, Mr. Vincent.
Mr. Dwayne Irving was the one in the closet, and the narcotics were falling out. And Mr. Desmond Irving was the one that was found with the gun, or the gun was found in the pathway of where he was attempting to flee from the police in the search warrant. Judge, I have Mr. Desmond Irving as a HAB second offense notice.
De Niro. It's De Niro. It's Robert De Niro, not Desmond.
Oh,
That's
I'm
the name
sorry.
of the co-defendant.
That was Freudian. I apologize. Mr. De Niro Irving, I have him as a HAB second offense notice. But as you can see, where I'm putting more of my effort is in the idea that we have over 500 folds of fentanyl and crack. We just find this to be a danger, whether or not defense counsel attempts to persuade you that this isn't assaultive. This is a clear and present danger, that this isn't for personal use. This is to deliver, to manufacture, to distribute, and that affects the entire community. So respectfully asking for the cash as well as the personal on these respective defendants.
Judge, we don't know what Mr. Irving's intent is. We don't know if Mr. Irving actually really possessed something. Was he there? Was he just around something? I don't know, Judge, but I get what Mr. Vincent says about the content and the quantity, but the stuff just sitting there, Judge, I mean, I don't know what the danger is at this present time. I mean, I know what the danger is in a black eye and a broken arm and a gunshot wound. I know the danger in that. Now, Judge, here we don't have any of that. We don't have any of that. We simply have a possession. People saying delivery. I don't know. I don't know if anybody got anything delivered. But right now, Judge,